right, welcome everybody to Stanton IP Law Firm's IP over T, and today we're going to be talking about trademark litigation strategy. The last one we did a couple of weeks ago, we talked about why software companies should care about getting patents. So what we're trying to do is every couple of weeks we're trying to just do a little bit of an educational element around intellectual property. That's what we focus on here at this firm. We focus on patents, trademarks, copyrights, trade secrets. We specialize on being able to acquire those protections for you and your company, as well as defending them through litigation. So really, again, the goal is really just to try to educate as best we can around these topics with everything going on that's just crazy right now with from pandemics to civil unrest to elections. There's just a lot of uncertainty going on right now. But one thing is for certain is that people are looking at new ways to protect their brand, to protect their companies, to protect their marketing dollars, and protect their investments. And so a big part of that is trademarks. And that's what we're going to spend our time on today. We're going to go ahead now and put up the presentation for you to be able to view. Let's see. Erica, can you share that? So we'll get that up here in just a second. One of the always fun parts of this is getting the technology to work right for us. Oops. Eric, are you able to get that up? Bear with us 1 second. We'll jump right into this. If not, I can do it right here. Perfect. All right. All right, hopefully this will be able to be shown here. Oops. All right, perfect. So, oops. There we go. Share this. Come on. There we go. All right. So sorry about that. So we're going to talk about kind of the trademark litigation strategy today. So let's jump right into that. We'll do a real quick overview. I already did it about the firm. We're going to talk about how the best defense is a good offense. The knowledge, the good and the bad about kind of trademark protection, and then strength of your brand, and then we'll jump into questions. All right, so again, we're talking a little bit about the firm. We started in 2017. We are at currently a little over 10 employees. We've served well over 250 clients in the last 3+ years. We're very tech, you wouldn't know it by my recent attempt to get this thing on our presentation up, but we are very tech savvy. We have this whole remote issue that came up. We're very tech enabled, so it made working from home very easy, which was very nice. And like we talked about, been involved in over 100+ patents, well over 300, 400 trademarks. It's really what we do and live and breathe every day. A little bit about here, trademark infringement cases have been the only steady statistic, making up about 48% of all IP cases. So, there's some big name cases that a lot of people are familiar with various brands. But everybody from the large company down to the small company care about their brand, right? It's very important. McDonald's has done a ton of fights against it. Apple they're arguably brutal about their defense of their brand. Huge amount of cases are in New York and Florida. I think a lot of that has to do with the fact that we have so many people just there's just a lot of people in New York and Florida, right? And a lot of businesses, a lot of hospitality, a lot of brands that are in the consumer's face, if you will. So let's jump right into this. The best defense is a good offense. What does that mean? Well, really there it comes down to, when you're talking about your brand and talking about your trademark, there's three types of protection. There's common law, and that's just something that's just, it's built into you. You get common law rights from the moment you start using your brand in connection with a good or a service. So you do have some built-in protections just by turning on the lights and opening up shop. But that protection is limited. And so it's limited because it only protects really whatever customer base you reach. And it doesn't give you a lot of strength, although it is defensible and it is usable, and there are plenty of successful cases that use common law trademark rights. It's one of those things that when you think about how do you protect your business, do you want to go try to defend yourself with a broken down handle, or do you want to defend yourself with a nice big hammer, if you will, right? And so we look at it as how do we help you as the client, as the business, enable yourself to give yourself the biggest hammer you can when going after someone from a protection perspective or an infringement perspective. So you have common law registration, which is kind of default built in. You have state registration. And state registration provides some protections, not a great deal, but it does provide some. One unique element is like within Florida, within the Florida Statute of Trademark, there is a prevailing parties attorney's fee statute. So typically in America, the American rule of law, basically the American court system says both sides cover their own fees, and except in rare circumstances. One is it's contractually based. You have it in the contract that both parties sign, that one party or the other would pay attorney's fees, or it's statute, and there's very few statutes that have it. And one of the statutes is Florida's trademark statute. So if you have an infringing party and you're in the state of Florida, now not everybody here is in the state of Florida, but other states have some elements of differences within that. Some have the prevailing party, some do not. But for that part, there's some benefit, but otherwise there's not a huge benefit to the state registration. It is, again, limited to the state. Federal registration is typically when we talk about, do you have a trademark? Do you have a trademark registration? It kind of defaults to the USPTO, the United States Patent and Trademark Office, and their federal registration. There's always little exceptions within the law, but without going into too many rabbit holes with it, as a general rule, when you have a U.S. trademark registration and you have it officially registered, you get your number, so on and so forth, you get the presumption of doing business in all 50 states with that trademark, with that name. So that's where it's really helpful. So if, for example, you have a business in Georgia and you do business in Georgia and South Carolina, let's say, and you have a U.S. registration, and somebody opens up something very similar name and similar type of service or good that you offer, and they're in California, you have a U.S. registration, you've got a good opportunity to go after them and say, wait a minute, you're infringing upon my brand, you're diluting my brand, there's a likelihood of confusion amongst our customer base, therefore you need to cease and desist, basically. So it gives you, again, that bigger hammer to go after them. If you had only the common law, you would have almost no shot of getting them to stop because you only service customers in a certain geographical area, and therefore your common law trademark would not reach. So that's where it really comes into play. So the good and the bad kind of knowledge, right? So knowledge is an interesting thing within trademarks. Knowledge comes into play because so let's start from the beginning a little bit, in the sense of you get a trademark registration for your business. There is no government entity that's running around looking for infringers to enforce your brand for you. It just doesn't work that way in the U.S. Some other countries around the world that have different types of systems, some have actual agencies that will go around and look for people that are infringing and stuff like that. Not in the U.S. It's your job as a trademark owner to enforce your brand. So that job's on you. That means you have to spend the money to go and stop somebody. And this is where the knowledge part becomes very interesting. If somebody's infringing upon your brand, but you do not know it, you don't know they are out there, you do not have the obligation to look under every rock to see who's infringing. Okay? So that's one thing to think about. So meaning you're allowed to keep your head in the sand, so to speak, and not worry about losing your trademark rights. Okay? Now there's always some argument there if someone, you know, if you're trying to go after Apple computers and they're in your face and you try to pretend like you didn't know they existed, right? There's a limit to that. But what it does mean is that you are not required to monitor any infringers, that sort of thing. However, if you do find out, if you do have knowledge, now the onus turns on to you, because as the trademark owner, as the brand owner, you now have the onus to defend your brand. So if you find out that somebody's infringing upon your brand and you don't do anything about it, there isn't necessarily a set time frame set in stone. There isn't a year goes by or 6 months or 2 years or 5 years or whatnot goes by. There isn't really a set number of time where your trademark rights get diluted, if you will, but over a period of time, your brand rights dilute because you're not enforcing them. So what does that mean? Well, that means that you can't pick and choose who you go after. So if your name is, I don't know, let's just use one of the big guys' names. Let's use Apple Computers. So if you're Apple and you go, well, you know what, these guys, they're small, I don't care about them. They're called Apple, but they're in, you know, I don't know, Des Moines, Iowa, and they're not really a big deal to us. And then there's someone in Florida that's called Apple, and they're in technology too, but they're really doing well. They're growing fast. So they go, you know what, we're not going to worry about the small Apple. We know about them, but we're going to go after the bigger ones. What happens if you do that is then you give defenses to the company you go after, because now they can raise up their flag and they can say, wait a minute, you came after us, but you didn't go after them, and you knew about them. So therefore, it's effectively an abandoning of your rights, right? So you got to be careful about that, because I oftentimes talk to clients and they go, oh boy, you know, Salesforce or Apple or Under Armour and you know, pick your big company. I can't afford to go after them. And a lot of times the answer is you can't afford not to, because generally we're not talking about going after the big brands for their main brand, right? Generally we're going after their sub brand. So, you know, they're going into a different line of business and they come up with a name. And we've got a client right now we're dealing with, I won't get into the company name, but they're dealing with a company out of San Francisco. They're fairly well funded, you know, fairly decent size. My client's not small, but they're not large either. And, you know, we had to have a conversation about, do we really want to go after them? Can we afford it? And it comes back to, can you afford not to? Because it's a clear, our client in this case has clear first use rights. They've been around longer. They have their trademark in place. And these guys out of San Francisco are coming in and trying to, not purposely, there's nothing that we can tell is malicious about it, but they've come forth with a name that's very similar, really actually identical name, and they're in this very same class of services. So you really don't have a choice once you find out about that. So the knowledge and the good and the bad is, the good is, you know, the more you know, the more you can protect your brand. The bad is, the more you know, the more you have to protect your brand. So that has to be part of your business plan and business model, and understanding that if you don't have a little carve out of, for quote unquote legal fees, right, around this stuff, you know, it can kind of hit you quick. And if you're not careful, you can find yourself being forced into, and this is not uncommon, deciding whether or not you defend your brand and you spend X amount of dollars that you don't have allocated for it, or you potentially look at changing your name, changing your brand, right? So, you know, being in a position where you understand that is very important from a strategy perspective. So now that you know that, and now that you find out somebody's infringing on your brand, now you get into, okay, well, you know, the title of this webinar was Litigation Strategy, right? Trademark Litigation Strategy. Strategy for litigation actually starts way before you ever get into litigation. There's clear strategy involved once you're in litigation, and there's strategy that you can choose and pick and choose. But quite honestly, once you're in litigation, your ability from a strategy perspective is much more limited than it is before litigation. Because before litigation, we're not working within a confines of rules, right? We can do a business deal, right? We can get a license agreement. We can get somebody to stop because they're concerned about cost of litigation. We can work out a consent agreement or a coexistence agreement with somebody, right? Like we can offer them a license fee and they can pay us or we can pay them, right? There's plenty of options that can happen. Once you're in litigation, right? Now, a lot of those settlement options can still be on the table, but from a strategy perspective, right, you're now limited in terms of what you can and cannot do because you're now within the courts themselves, right? So there is it's very important to have a good strategy once you're in litigation and a complaint's been filed and you're dealing with that. But you can avoid a lot of that expensive litigation if you have a good litigation strategy in place before you actually have to get involved in litigation. So these are kind of the four elements that you're really going to be thinking about when dealing with how to protect your brand and then ways of finding potential weakness in a infringing brand. So likelihood of confusion is generally the most notable one. So likelihood of confusion means it's a funny one, Coming to America, right? He was, McDougal's or whatever, right? And, he makes burgers and he doesn't put sesame seeds on his bun like McDonald's, right? That sort of thing, right? So that's a clear likelihood of confusion, right? That's a very blatant one. He wants people to think he's McDonald's, but he's not exactly McDonald's. And he does that to be able to use the goodwill and the brand recognition that McDonald's has built over the years to do that. So in real life, that becomes a clear violation that McDonald's goes after them for, right? In the movie, it becomes a very great comedy bit. So likelihood of confusion is pretty well, if you didn't know the exact legal term, you knew what it meant, right? Someone has a name, someone has a similar name, and people see that similar name and they think it's the more popular or the well-known name or the name that was around first. So that's what's likelihood of confusion. Now, likelihood of confusion has its limits. It has to be the same or similar name and the same or similar service, not or, it's and, because think about Delta Airlines and Delta Faucets, right? Same name, totally different industries. Nobody's confused into thinking that Delta Airlines is now making faucets or vice versa. But if you narrow that gap and let's say you have Delta Airlines and now you have Delta Airport, right? Or now you have Delta car rental, right? Okay, well now you start getting closer, right? Now you start getting to a point where, okay, maybe the customer would be confused to thinking that Delta Airlines is now involved in car rentals, right? That's not a huge leap. Going to faucets is a big leap. So that's your likelihood of confusion question. So when looking at, is somebody infringing on my brand or am I infringing on their brand, that's generally the first question you're going to ask. How likely is it that a customer is to be confused? Now, I won't go into the 7 steps that are involved in all of these, whether there's a legal conclusion of likelihood of confusion, but I always like thinking, let's just start with the basic logical sense. Is there a potential confusion? And if there is, then we should, we got to kind of run that up the flagpole and think much stronger or harder about it. If there's not, then we can tell someone that. And tell them to pound sand, and we have a good chance if they decide to sue us, that sort of thing, right? But it requires an analysis. Your next analysis will go into descriptiveness. So descriptiveness means that the name itself, right? You're basically somebody, and people try this all the time, and there's nothing wrong with it. Marketing 101 says name your good or service very close to what it is so that your consumers, your customers know what it is that you do, right? Trademark 101 is the exact opposite. We do not, as a society, want to allow you to protect a name that means what it, that's the name used to describe what it is that you do. the English dictionary has already done the work for you, right? So why can you take credit for that, right? So if I have a chair making company and I call my company Chairs, right, I should not be able to protect my brand, because that means that anybody that also builds a chair, that calls it a chair, I would be able to go after, right? So that's the extreme level of descriptiveness. Now, descriptiveness has varying degrees as well. Under descriptiveness, you've got generic, which is kind of what I just said, chair, that's very generic. You've got highly descriptive, which would be, you know, I don't know, sit on device, right? Or sit on chair, sit on something, right? You know, where you're really highly describing it. And then you've got merely descriptive, where you just call it, maybe you call it seat, right? Or something like that, where it's not exactly understood what it is you do, but it gives you a very clear understanding that it's in that area, right? It's in that space, if you will. So there's varying degrees of descriptiveness. So you can also have geographic descriptiveness. So, you know, if you're in New York, and you call yourself New York Pizza, right? It's hard to protect that if you're in New York. Now, if you're in Miami and you call it New York Pizza, you have a better chance of protecting it, right? Because it's not geographically descriptive anymore, right? So that comes into play too. So your next level of looking at whether or not your mark is strong or you are infringing on somebody's mark is the descriptiveness part of it. So I've got a client right now we're dealing with, and there's someone's coming after them, and their name is after a name of a street. And that's very descriptive, right? That's very geographically descriptive. And my client has the same name, but he's not on the street. And so, you know, we need to look at those things. So that's part of how you determine kind of the strength of your brand and where you're at on that. The more descriptive it is, I like to think of it as a cone of protection. The narrower the protection is. The less descriptive, such as, you know, Google, Nike, Apple, those sorts of things, the broader protection is, because let's take Apple. Prior to 1977, no one associated the fruit with technology, right? So they built that connection. Google, who knows what the heck that means, right? But they made up a word and they connected it, right? And they now everyone knows it as a search engine, right? So that's where the descriptiveness comes in, and the stronger, the less descriptive it is, the better chance you have of enforcing it. Abandonment's another thing. So abandonment, and we'll jump through these two here so we can get the questions and make sure we respect your time. Abandonment comes with, okay, I owned a trademark and then I haven't used it in, I don't know, a few years. And then you want to go and either enforce it, or somebody is coming after you because they own the trademark, but they haven't done anything with it in a few years, right? So we can look at those things as saying, well, wait a minute, you've abandoned your use. Like you can't, there's no such thing as quote unquote sandbagging trademarks. So they're not like domain names, right? For example, domain names, you can go out and buy a bunch and you can kind of sit on them, and it's not that they can't be taken away from you, but it's much more difficult. In trademark world, if you're not using it in the stream of commerce and it's not out there, now that doesn't mean you stop using it for a day, that tomorrow it's gone, but the way trademark law works is if you've not used it for 3 consecutive years, then it's called a prima facie case of abandonment. Okay, so that's the thing to kind of look at there. So if you're trying to get a brand and somebody else has one that's out there, but they haven't been using it for a period of time, this is one way to look at possibly doing it. And the flip side is, if you have a brand that you've been sitting on and haven't been using, don't think because you got a trademark 6 or 7 or 10 years ago that you have it forever, as long as you pay the renewal fee every 5 years or whatever. So you've got to make sure that it's in the stream of commerce. Naked licensing is an interesting little one too, because obviously that, well, not obvious, but that only comes into play when you have a brand owner that licenses it to a licensee, okay? So when you do that, typically you can only license a brand from like an exclusivity perspective, right? So that's, you generally are, you can have different outlets using your same brand, but you can't have the same brand be, a brand that sells tennis shoes and then the same name brand that sells shirts and that sort of thing from all different places, and so it confuses the marketplace. So you can't confuse the customer is kind of the idea behind it. So you have a licensor and you have a licensee, but that licensor doesn't do anything with the brand. He basically, or she just gives it away to the licensee and doesn't check quality, doesn't check up and make sure that they're, doing their, meeting their agreement, which is whatever the license agreement says, things like that. So in cases like that, that can actually work for you if somebody is coming after you and they're a licensee, and we can find out that it's a naked licensing. And more importantly, for those that are trying to license their brand, this is a very important reminder, which is don't just license it and then, set it and forget it, right? You've got to be active. You've got to be involved. You need to be looking at product, they're selling it under, making sure you're keeping the quality up, that sort of thing. Because at the end of the day, we in the U.S., and this is different than in other countries, but we in the U.S. come from a customer point of view. So we want our brands to represent quality and to represent consistency, right? And we don't want somebody going in and buying a Nike shoe in one store and getting one set of quality and then going to another store and buying a Nike shoe and getting something completely different, right? So that's the importance behind that. So with that, I'm going to see if we have any questions that have come in. And I know we're running a little bit low on time, but hopefully we can answer a few questions here. Erica, do you have some questions you can Slack me? And Erica is our Director of Marketing as well, and she's the one who I'm sure everyone here got messaged from and connected with, and she's done a great job in helping to get this all set up as well.
And I apologize about all that. Currently, no questions have come through on the chat. I have received some emails for consultation, so I don't have any questions right now. But I have allowed everyone to unmute themselves, so if anyone has a question, they can go ahead and unmute themselves and ask it. If you have questions like specifically related to your case, it's best just to email me for a consult, and that way you and Tom can talk about your specific business. But I'll be quiet now in case anyone has a question.
Well, that's good. That means I nailed it, right? Anyways, so with that, again, our goal here is to just kind of pass on some basic information to you.
All right.
Really to, oh, we got one?
Yep. So here's the first one. What if someone has a generic phrase trademarked like speed dating or networking event, but it's part of the description of what you offer?
So that becomes interesting in the sense of, it really goes to the descriptiveness part of it, right? So we also get into a much more deeper conversation, which is, so, there's two bodies of protection when we talk about trademarks, and this is true with patents and copyrights as well. So with trademarks, we have U.S. we have the registration process. So when we go through, let's just say the USPTO, not all examiners are created equal. What I mean by that is things get through that shouldn't, and things don't get through that should. And there are humans on the other side, and they make decisions and they think about things, and we don't always agree with them, right? So, that's one thing that you got to just kind of consider, right? So there's things that get registered as trademarks. Now, once they've been registered, they get the presumption of validity. So to invalidate them, the bar is a little bit higher. But if some things are super obvious, then then your chances of overcoming that are higher. But again, it's frustrating because now you got to spend money to kind of fight them on that, right? So if somebody calls themselves speed dating, and that's what they do is speed dating, that's generally a very, very weak mark that if it was in those limited context of someone has speed dating and they offer speed dating, and you say, we offer speed dating too, and they try to sue you for that. That's something that I think most trademark attorneys, I know there's a couple on the call today too, we would probably all smile and feel very comfortable with defending you on. And the flip side is we'd feel less confident going after somebody for that because of it's so generic and descriptive in that respect. So, you know, it's important to understand that there's the registration process, which doesn't necessarily always follow the law perfectly. And then you have the enforcement side of it. So there's a couple mechanisms you can use. So if something is very descriptive that shouldn't have gotten through but did, there's what's called a cancellation proceeding that can be filed with the USPTO to say, hey, this shouldn't have gotten through. This is ridiculous, right? And it goes in front of the Trademark Trials and Appeals Board, and you can go that route. The other way is you can end up in federal court, and you can go that route. Now, obviously and unfortunately, those are not necessarily terribly cheap processes. The cancellation proceeding is much cheaper in general than the federal court piece, but there are mechanisms to go and right the wrong, so to speak. But you know, that's just something you deal with. Now, there are times where, you know, a kind of more of a standard name can become protectable, such as like Burger King or something like that, right? Where it's pretty descriptive, but they've carved out their distinctiveness where when someone says Burger King, you're not thinking of, you know, Uncle Joe's burger in his backyard as being the king of burgers, right? You're thinking of the fast food place Burger King, right? So out of the gate, not as strong of a trademark, but as you get, you know, more and more into your brand distinctiveness and brand recognition, then it's acquired that distinctiveness, even though it's a bit descriptive. So hopefully that answers your question a bit of a roundabout. I got one question that sent over too, which was, how do you compete with these online trademark registration companies who seem to be fairly automated? So great question. We deal with those a lot. So a lot of the trademark registration companies are not attorneys. So they're basically just taking, you know, in many respects, going through them, you could also just go direct to the USPTO website and fill out their forms. Because what they typically do is they typically take the USPTO forms and they just put a skin over it, and that makes it a tad bit more user-friendly. So we don't necessarily feel like we compete that much with them because the benefits you get are the knowledge that we're talking about here, right? You're not paying us to click the form, right? I mean, you know, like you can click or you can have an automated person to click, but what goes into that field and how your description is, what class you choose, whether or not your name is going to get through because of some other name that's out there, and analyzing that, right? That's what you come to us for. So if you already know exactly what you want and it's available and it's, you know exactly your description and so on and so forth, and all you need is somebody to click through some buttons, these registration companies are great for that. But as soon as you run into a problem, that's where their resources get limited. So hopefully that answers that. Erica, do you have one more?
I don't have any more questions. Okay. I did want to let everyone know that Jim Harrison has won our whiskey set giveaway. So Jim, if you can just go ahead and email me your address, we'll get that shipped out to you. And I do have a few attorneys that have been messaging me, so I'll get back to you guys about the next webinar that's for attorneys only. But thank you everyone for participating, and I hope to hear from you if you want to talk to Tom directly.
Yeah, thank you everybody. Really appreciate it. Have a great rest of your week. And as she mentioned too, we'll also get a link posted too. So if you want to rewatch this because it was so exciting, or you want to share it with friends or whatnot, we'll have that available. So thank you guys. Appreciate it.
Take care, everyone. Bye-bye.